Part 3, Building Permits. Division 1, Building Permit Required. 16 offenses relating to carrying out building work. 1. A person must not carry out building work unless a building permit in relation to the work has been issued and is in force under this Act. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 2. A person must not carry out building work unless the work is carried out in accordance with this Act, the building regulations, and the building permit issued in relation to that work. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 3. An owner of land must ensure in relation to building work carried out on that land that a building permit in relation to the work has been issued and is in force under this Act. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 4. A building practitioner, an endorsed building engineer, or an architect who is engaged to carry out building work must ensure that a building permit in relation to the work has been issued and is in force under this Act. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 4a. A builder named in a building permit must ensure that the building work to which the building permit applies is carried out in accordance with this Act, the building regulations, and the building permit. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 5. Subsection 3 does not apply to an owner if the owner has engaged a building practitioner, endorsed building engineer, or architect to carry out the building work on that land. 6. Subsections 1, 2, 3, 4, and 4a do not apply if the building work is exempted by or under this Act or the regulations. 16a. Exception if permit suspended. 1. It is an exception to an offense under Section 16, 1, 3, or 4 if a building permit was not in effect because it was suspended under Section 25AE and the accused at the time of the alleged offense A. was not aware that an event mentioned in Section 25AE, 1, had occurred in relation to the building permit, and B. could not reasonably be expected to have known that the event had occurred. 2. The exception in subsection 1 does not apply to the accused if the accused is an architect or a building practitioner who is engaged to carry out the building work to which the building permit applies. 16b. Indictable offenses relating to carrying out building work. 1. A person who is in the business of building must not carry out building work for which a building permit is required if the person knows that A. A building permit is required to carry out that work, and B. A building permit to carry out that work is not in force. Penalty: 600 penalty units, or imprisonment for 5 years or both, in the case of a natural person. 3,000 penalty units, in the case of a body corporate. 2. An offense against subsection 1 is an indictable offense. 3. A person who is in the business of building must not carry out building work if the person knows that the building work is not being carried out in accordance with A. this Act, or B. the building regulations, or C. the building permit issued in relation to that work. Penalty: 600 penalty units, or imprisonment for 5 years or both, in the case of a natural person. 3,000 penalty units, in the case of a body corporate. 4. An offense against subsection 3 is an indictable offense. 5. Subsections 1 and 3 do not apply if the building work is exempted by or under this Act or the regulations. 6. In this section, person in the business of building includes a person who is in the business of managing or arranging the carrying out of building work. Division 2. Applications for building permits. 17. Applications for building permits. An application for a building permit may be made to a municipal building surveyor or to a private building surveyor appointed under Part 6. A. By or on behalf of the owner of the building, or the owner of the land, in or on which the building work is to be carried out, or B. If the land in or on which the building work is to be carried out is a lot of a kind referred to in Section 9AA, 1, of the Sale of Land Act 1962, by the purchaser under a contract for the sale of that lot. 18. Schedule 2 to apply. Schedule 2 applies in relation to an application for a building permit under this part. Notes: 1. A person applying for a building permit must pay the building permit levy calculated under Subdivision 4 of Division 2 of Part 12. 2. An application for a building permit must include information that enables the building permit levy to be calculated. See Section 205H1 and 1A. 18. A relevant building surveyor must apply for building permit number for building permit. 1. On accepting an application for a building permit in relation to building work, the relevant building surveyor must apply to the authority for a building permit number for the proposed building permit. 2. An application under subsection 1 must A. Be in writing in the form, if any, approved by the authority, and B. Include the cost of the proposed building work estimated by the relevant building surveyor under Section 205I, and D. Include the prescribed information relating to the proposed building permit and building work to which the permit relates. 3. The relevant building surveyor may consider the application pending the issue of the building permit number for the building permit. 18. A notice to Development Victoria of application. 1. This section applies if A. An application for a building permit relates to the carrying out of building work on land in a project area within the meaning of the Development Victoria Act 2003, and B. A resolution is in force under Division 5A of Part 3 of that Act levying a general development charge or an infrastructure recovery charge in respect of that project area. 2. The relevant building surveyor must without delay A. Notify Development Victoria in writing of I. The application, and 2. The cost of the building work estimated under Subdivision 4 of Division 2 of Part 12, and 3. Any refusal of the application under Section 205HA, and 4. Any decision of the Building Appeals Board to modify the cost of the building work, and B. Provide Development Victoria with a copy of any relevant planning permit that authorizes both the construction of the buildings to which the building work relates and a subdivision of the land on which the building work is to be carried out. 18. B. Notice to Commissioner of State Revenue of application. 1. This section applies if A. An application for a building permit relates to the carrying out of building work on land in respect of which there is a GAIC recording, within the meaning of Part 9B of the Planning and Environment Act 1987, and B. The application is not an excluded event, within the meaning of Section 201RB of that Act, and C. None of the circumstances described in Section 201SA of that Act applies to the land. 2. The relevant building surveyor, within 14 days after receiving the application, must give a notice of the application to the Commissioner of State Revenue referred to in Section 62 of the Taxation Administration Act 1997. 3. A notice under subsection 2 must contain the following information. A. A description of the land. B. A description of the building work specified in the application and the purpose of the building work. C. The date the application was made. D. The applicant's name and contact details. E. The name and contact details of any owner of the land, if the applicant is not the owner. F. The estimated cost of the building work specified in the application. 18. See further notice to Commissioner of State Revenue. 1. This section applies if A relevant building surveyor has given a notice to the Commissioner of State Revenue under Section 18B, 2, relating to an application for a building permit described in Section 18B, 1A, and B. The relevant building surveyor receives a notice from the authority under Section 205 LB 1b stating that the estimated cost of building work relating to the application has increased, and C. The increase in the estimated cost of building work means that the application is no longer an excluded event within the meaning of Section 201 RB of the Planning and Environment Act 1987, and D. None of the circumstances described in Section 201 SA of the Planning and Environment Act 1987 applies to the land on which the building work is to be carried out. 2. The relevant building surveyor must give a further notice of the application to the Commissioner of State Revenue containing the following information. A. A description of the land on which the building work is being or is to be carried out. B. A description of the building work specified in the application and the purpose of the building work. C. The date the application was made. D. The applicant's name and contact details. E. The name and contact details of any owner of the land, if the applicant is not the owner. F. The cost of the building work estimated under Subdivision 4A of Division 2 of Part 12. 3. A notice under Subsection 2 must be given within 10 business days after the relevant building surveyor receives the notice under Section 205 LB 1b from the authority. 18D. Notice to Secretary to Department of Environment, Land, Water and Planning of application. 1. This section applies if A. An application for a building permit relates to the carrying out of building work on land in respect of which there is a levy recording, within the meaning of the Melbourne Strategic Assessment, Environment Mitigation Levy, Act 2020, and B. The application is not an excluded event within the meaning of that Act. 2. The relevant building surveyor, within 14 days after receiving the application, must give to the Secretary to the Department of Environment, Land, Water and Planning A. A notice of the application, and B. A copy of the application and any documents that accompany the application. Note the regulations may prescribe documents which may be required to accompany an application. See Clause 1b of Schedule 2. 3. A notice under Subsection 2a must contain the following information. A. A description of the land. B. A description of the building work specified in the application and the purpose of the building work. C. The date the application was made. D. The applicant's name and contact details. E. The name and contact details of any owner of the land, if the applicant is not the owner. Division 3. Decisions on building permits and other matters. 19. Decision on application for building permit. 1. The relevant building surveyor must decide an application for a building permit by A. Issuing the permit, or B. Issuing the permit with conditions, or C. Refusing the permit. Note the relevant building surveyor must refuse a permit if an order under Section 131 of the Planning and Environment Act 1987 is in effect and applies to the land to which the permit application relates unless the permit is for building work in respect of a development that is specified in the order as an exception. See Section 132 of that Act. 2. The regulations may prescribe a time within which the relevant building surveyor must decide an application for a building permit. 3. The relevant building surveyor is taken to have refused a building permit if the application is not decided within the prescribed time. 20. Types of permit. A building permit may be A. A permit for the whole of the proposed building work, or B. A permit for a stage of proposed building work. 21. Requirement for occupancy permit. 1. The relevant building surveyor must specify in a building permit A. Whether an occupancy permit is required under subsection 2, in respect of the building work, and B. Whether the occupancy permit is required for the whole or part of the building in respect of which the building work is carried out. 2. An occupancy permit is required in respect of all building work except A. Building work which the relevant building surveyor considers to be minor, or B. Building work which the relevant building surveyor considers does not compromise the suitability of the building for occupation, or C. Prescribed building work. 22. Guarantees and bonds. In prescribed circumstances, A building permit may be issued subject to a condition that the applicant deposit with the relevant council or, in the case of a permit issued by a private building surveyor, with the authority. A bond for an amount determined in accordance with the regulations, or B. An undertaking to pay that amount together with a guarantee provided by a body that is permitted to use the expression bank under Section 66 of the Banking Act 1959 of the Commonwealth. To secure the complete and satisfactory carrying out of the work authorized by the building permit. 23. Reporting authority to be notified of permit. If the relevant building surveyor issues a building permit, which differs from or fails to implement the recommendations in a reporting authority's report under Schedule 2 on the application for the permit, the relevant building surveyor must notify the reporting authority, without delay of the permit, and give the reporting authority a copy of the permit. 23A. Offenses relating to the issue of a building permit. 1. The relevant building surveyor must not issue a building permit unless the authority has issued a building permit number for that building permit. Penalty: 500 penalty units in the case of a natural person. 2,500 penalty units in the case of a body corporate. 2. The relevant building surveyor must not issue a building permit unless the permit specifies A. The building permit number issued by the authority for that building permit, and B. Any other information required by the regulations to be specified in the building permit. Penalty: 10 penalty units in the case of a natural person. 50 penalty units in the case of a body corporate. 24. Refusal of building permit. 1. Subject to Section 24A and Division 4, the relevant building surveyor must not issue a building permit unless he or she is satisfied that A. The building work and the building permit will comply with this Act and the building regulations, and B. Any consent of a reporting authority required under this Act, or the regulations, or under any other Act or regulations is obtained or taken to have been obtained in accordance with Schedule 2, and C. Any relevant planning permit or other prescribed approval has been obtained, and D. The building permit will be consistent with that planning permit or other prescribed approval. 2. Subject to Section 24A and Division 4, the relevant building surveyor must not issue a building permit that imposes on the applicant lesser or greater standards or requirements than those prescribed by this Act or the building regulations, unless permitted to do so by this Act or the building regulations. 3. The relevant building surveyor must not issue a building permit for the carrying out of building work for which notice is required to be given to Development Victoria under Section 18A unless Development Victoria has notified the relevant building surveyor under Section 51ZA of the Development Victoria Act 2003 that A general development charge or an infrastructure recovery charge is not payable in respect of the building work for which the permit is to be issued, or B. If a general development charge or an infrastructure recovery charge is payable in respect of that building work, the charge has been paid, or the person liable to pay the charge has entered into an agreement with Development Victoria under Section 51Y of that Act to pay the charge. 4. The relevant building surveyor must not issue a building permit for the carrying out of building work on land in respect of which there is a GAIC recording, within the meaning of Part 9B of the Planning and Environment Act 1987, unless the applicant produces any of the following certificates relating to that liability issued by the Commissioner of State Revenue under that part. A certificate of release. B. A certificate of exemption. C. A certificate of staged payment approval. D. A certificate of no GAIC liability. Note: under Part 9B of the Planning and Environment Act 1987, the Commissioner of State Revenue must issue a certificate of release if the person liable to pay a growth area's infrastructure contribution has been released from that liability for various reasons, including the fact that the person has paid the contribution or had the contribution totally reduced. The Commissioner must also issue a certificate of exemption under that section if the person liable to pay a growth area's infrastructure contribution is exempt from the liability to pay the contribution. The Commissioner must also issue a person with a certificate of staged payment approval if the person has been given approval for the staged payment of the contribution. 4A. The relevant building surveyor must not issue a building permit for the carrying out of building work on land in respect of which there is a levy recording, within the meaning of the Melbourne Strategic Assessment, Environment Mitigation Levy, Act 2020, unless the applicant produces any of the following certificates issued by the Secretary to the Department of Environment, Land, Water and Planning under that Act. A. A certificate of release in relation to the land. B. A certificate of staged payment approval in relation to the land. C. A certificate of no liability in relation to the application for the building permit. Asterisk, 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 asterisk. 5. If an amount of community infrastructure levy is payable under Part 3B of the Planning and Environment Act 1987 in respect of a development for which building work is required, the relevant building surveyor must not issue a building permit in respect of that building work unless he or she is satisfied that A. That amount of levy has been paid to the relevant collecting agency under that part, or B. An agreement to pay that amount of levy has been entered into under that part. 6. If a monetary component amount and any land equalization amount of an infrastructure contribution imposed under an approved infrastructure contributions plan is payable in respect of the carrying out of building work, the relevant building surveyor must not issue a building permit in relation to that building work unless the applicant satisfies the relevant building surveyor that A. Those amounts have been paid to the collecting agency in accordance with Section 46 GV 3 of the Planning and Environment Act 1987, or B. The applicant has entered into an agreement with the collecting agency under Section 46 GV 3 of that Act for the payment of those amounts. 7. If any land component of an infrastructure contribution imposed under an approved infrastructure contributions plan in respect of the carrying out of building work includes the provision of inner public purpose land, within the meaning of Part 3AB of the Planning and Environment Act 1987, the relevant building surveyor must not issue a building permit for that building work unless the applicant satisfies the relevant building surveyor A. That the inner public purpose land has been set aside as a road or reserve on a plan under the Subdivision Act 1988 to vest in the collecting agency or a development agency, as the case requires, under that Act, and B. The plan has been lodged for registration under Section 22 of the Subdivision Act 1988. 24A. Further limitations on the issue of building permits. 1. The relevant building surveyor must not issue a building permit in relation to building work unless the relevant building surveyor is satisfied that A. The building work is to be carried out by a builder who is specified under Section 24B for that work, and B. The builder is named in the building permit, and C. In the case of building work carried out under a major domestic building contract, I. If the cost of the building work exceeds the prescribed amount. A. If the builder is not a member of a partnership, the name of the person who is named as the builder in the contract is identical to the name of the person specified as the builder in a certificate of insurance, or B. If the builder is a member of a partnership, the name of the builder and the name of the partnership specified in the contract is identical to the name of the builder and the name of the partnership specified in a certificate of insurance, and 2. The major domestic building contract was entered into by a person entitled to do so under Section 29 of the Domestic Building Contracts Act 1995, and D. In the case of a builder who is a body corporate, there is specified in the building permit the name of a natural person on whom directions, notices, and orders under this act directed to the body corporate can be served. 2. The regulations may specify the manner in which the relevant building surveyor may be satisfied on the matters in subsection 1 CI. 3. In subsection 1 CI. Prescribed amount means A. The amount prescribed by the regulations, if any, or B. If an amount is not prescribed, $16,000. 4. In this section, certificate of insurance means a certificate of insurance from the insurer providing the required insurance in relation to the building work. 24b Specification of builders in relation to specific building work. 1. This section specifies builders for the purposes of Section 24A(1)(a). 2. If the cost of the building work does not exceed the prescribed amount for this subsection, the builder must be a building practitioner, or b. the owner of the building or land in or on which the building work is to be carried out, or c. an architect who is registered under the Architects Act 1991, or d. an endorsed building engineer. 3. If the building work is not domestic building work, and the cost of the building work exceeds the prescribed amount for subsection 2, the builder must be a registered building practitioner other than a provisionally registered building practitioner, or a provisionally registered building practitioner, if their registration authorizes the carrying out of all of the building work under the proposed permit, or b. the owner of the building or land in or on which the building work is to be carried out, or c. an architect registered under the Architects Act 1991, or d. an endorsed building engineer. 4. If the building work is domestic building work being carried out under a major domestic building contract, the builder must a. be the builder who entered into that contract, and b. be registered, other than provisionally registered, under Part 11, and whose registration authorizes the carrying out of the work. 5. If the building work is domestic building work not being carried out under a major domestic building contract, and the cost of the work exceeds the prescribed amount for subsection 2, but does not exceed the prescribed amount for Section 25b, the builder must be the owner of the building or land in or on which the building work is to be carried out. 6. If the building work is domestic building work not being carried out under a major domestic building contract, and the cost of the work exceeds the prescribed amount for Section 25b, the builder must be an owner referred to in Section 25b of the building, or land in or on which the work is being carried out. 7. In this section, the cost of building work is the cost of that work estimated under Subdivision 4 of Division 2 of Part 12. 8. In subsection 2, prescribed amount means a. the amount prescribed by the regulations, if any, or b. if an amount is not prescribed, $5,000. 25 reasons for refusal to be given. The relevant building surveyor must notify an applicant for a permit in writing, without delay of the refusal of the permit, and the reasons for the refusal. 25 A person may notify relevant building surveyor, if becomes owner of land subject to building permit. 1. If a person becomes the owner of land that is subject to a building permit that has been suspended under Section 25A(1)(d), and the remaining building work under the building permit is to be carried out by an owner-builder, the person may notify the relevant building surveyor that the person is the new owner of the land. 2. A notice under subsection 1 must include the following information. A request that the new owner under subsection 1 be named as the builder on the building permit. B. If a certificate of consent has been issued to a person to carry out the remaining building work under the building permit, a copy of the certificate of consent. C. The name and address of the new owner, and any person issued with a certificate of consent to carry out the remaining building work under the building permit if that person is not the new owner. D. Any information or documents requested to be provided by the relevant building surveyor in order for the relevant building surveyor to decide whether the new owner may be named as the builder on the building permit. E. Any other prescribed information. 25. A notice of ending of engagement of builder. 1. This section applies if a building permit is issued in relation to building work to be carried out by a building practitioner, an endorsed building engineer, or an architect registered under the Architects Act 1991, the builder, and b. Subsequently the engagement of the builder ends before completion of the building work. 2. The builder or the owner of the building or land in or on which the building work is to be carried out may give a notice of the ending of the engagement to the relevant building surveyor. Note: the effect of this notice is that the permit is suspended under Section 25A. 3. A notice under subsection 2 may be in a form approved by the authority, if any. 4. For the purposes of Section 25AE, 1e, the day on which the engagement ceases is a. The day on which the relevant building surveyor receives the first notice under subsection 2, or b. Any later day specified in that notice. 25AB notice to relevant building surveyor of subsequent engagement of builder. 1. This section applies if a building permit is issued in relation to building work, and whether or not the building permit is suspended, and b. Subsequently a building practitioner, an endorsed building engineer, or architect registered under the Architects Act 1991, the builder, is engaged to carry out the building work. 2. The owner of the building or land in or on which the building work is to be carried out may give the relevant building surveyor written notice of the engagement in accordance with subsection 3. 3. A notice under subsection 2 must include a. The name of the building practitioner and the building practitioner's registration number, the name of the endorsed building engineer and the endorsed building engineer's number or the architect's name and registration number, as the case requires, and b. If the engagement is to carry out domestic building work, and the cost of the work exceeds the prescribed amount, an extract of the contract showing the names of the parties to the contract, and a certificate of insurance from the insurer providing the required insurance in relation to the building work, and c. Any other prescribed details. 4. In this section, prescribed amount means a. The amount prescribed by the regulations, if any, or b. If an amount is not prescribed, $16,000. 25 AC change of builder on building permit on being notified under Section 25AB or 25AA2. The relevant building surveyor may change the builder named on a building permit if the relevant building surveyor is satisfied that the builder complies with the relevant requirements of Section 24A. 25 AD relevant building surveyor to notify authority and relevant counsel of certain information. 1. The relevant building surveyor must give written notice to the authority and the relevant counsel of the occurrence of each prescribed event and the prescribed information relating to that event which relates to a. The building work to which a building permit applies, or b. The building permit. 2. The notice must be given within the prescribed period after the relevant event. 3. In this section, prescribed period means the longer of a. The period prescribed by the regulations, if any, or b. 5 business days. 25 A. Suspension of building permit. 1. A building permit is suspended on and from the day on which a. If the builder named in the building permit is a building practitioner, the building practitioner's registration as a building practitioner is suspended or cancelled, or b. If the builder named in the building permit is an architect, the architect's registration as an architect is suspended or cancelled under the Architects Act 1991, or b. If the builder named in the building permit is an endorsed building engineer. I. The endorsed building engineer's registration as a professional engineer is suspended or cancelled under the Professional Engineers Registration Act 2019, or 2. The endorsed building engineer's endorsement to act as a registered professional engineer who is authorized to engage in the building industry is suspended or cancelled under the Professional Engineers Registration Act 2019, or c. The builder named in the building permit I. Dies, or 2. Is imprisoned for an offense, or 3. Has become a represented person within the meaning of the Guardianship and Administration Act 2019, or d. If the builder named on the building permit is the owner of land to which the building permit relates, the owner ceases to own the land, or e. The builder named in the building permit has ceased to be engaged to carry out the building work to which the permit relates. 2. A building permit ceases to be suspended under this section on the day on which a builder, who complies with the relevant requirements of Section 24A is named as the builder in the building permit. 3. A building permit is of no effect under this Act during the period that it is suspended under this section. 25B. Restrictions on owner-builder. 1. An owner of land or a building must not carry out domestic building work as builder on that land, or in respect of that building if the cost of the work, estimated under Subdivision 4 of Division 2 of Part 12, is more than the prescribed amount unless the owner A. has been issued with a certificate of consent for the work, or B. is a builder whose registration, other than a provisional registration, under Part 11 authorizes the carrying out of that work, or C. is an architect who is registered under the Architects Act 1991, or D. is the Director of Housing, or E. is carrying out the work in accordance with an emergency order, a building notice, or a building order made under Part 8. Penalty: 120 penalty units. 1A. An owner of land or a building who is required under this section to be issued with a certificate of consent to carry out domestic building work as builder must not enter into a major domestic building contract with another person to carry out the work, or any part of the work unless the person is registered, other than provisionally registered, as a builder under Part 11, and the registration authorizes the person to carry out that work. Penalty: 60 penalty units in the case of a first offense. 120 penalty units in the case of a second or subsequent offense. 1B, subsection 1A, does not apply to an owner of land or a building if the owner took reasonable steps to ensure that the person carrying out the building work is registered as a builder under Part 11, and that the registration authorizes the person to carry out that work. 2. In this section, prescribed amount means A. the amount prescribed by the regulations, if any, or B. if an amount is not prescribed, $16,000. Division 3A, issue of building permit number by the authority. 25BA, issue of building permit number. 1. The authority must issue a building permit number for a proposed building permit on receiving an application from the relevant building surveyor under Section 18A if A. the relevant building surveyor has given to the authority all of the information required under Section 18AA in relation to the proposed building permit, and B. the authority has been paid the whole amount of the building permit levy calculated under Section 205I in relation to the proposed building work. 2. A building permit number may be issued in the prescribed manner, if any. 25BB, authority may refuse to issue building permit number. The authority may refuse to issue a building permit number if A. the relevant building surveyor has not given the authority all of the information required under Section 18AA in relation to the proposed building permit, or B. the authority has not been paid the whole amount of the building permit levy calculated under Section 205I in relation to the proposed building work. 25BC, authority must decide to issue building permit number within prescribed period. 1. The authority must issue or refuse to issue a building permit number within the prescribed period after receiving the information and the building permit levy required under Section 25BA. 1. 2. The authority is taken to have refused to issue a building permit number if it has not made a decision to issue or refuse to issue a building permit number in accordance with subsection 1. 3. In this section, prescribed period means the longer of A. the period prescribed by the regulations, if any, or B. 5 business days. 25BD, authority must notify applicant of refusal to issue building permit number. 1. If the authority refuses to issue a building permit number for a building permit, it must give written notice to the applicant for the building permit of A. the refusal, and B. the reasons for the refusal, and C. the applicant's right to apply to VCAT for review of the decision to refuse to issue the building permit number. 2. Subsection 1 does not apply if the authority is taken to have refused to issue the building permit number under Section 25BC 2. 3. The authority must give a copy of a notice under subsection 1 to the relevant building surveyor. 25B, authority must notify council of issue of building permit number. After issuing a building permit number under this division for a building permit for building work to be carried out in or on a building or land, the authority must without delay, provide the relevant counsel with A. The building permit number, and B. The information given to the authority by the relevant building surveyor under Section 18AA in relation to the application for the building permit number. 25 BF Review by VCAT of refusal to issue building permit number. An applicant for a building permit may apply to VCAT for review of a refusal by the authority to issue a building permit number for the building permit under Section 25 BB. Division 3A Certificates of Consent for Owner-Builders. 25C Application for Owner-Builder Certificate of Consent. 1. A natural person may apply to the authority for the issue of a certificate of consent to carry out domestic building work on land. 2. The application must A. Contain the prescribed information, and B. Be made in the prescribed manner, and C. Be accompanied by I. The prescribed information, and 2. The prescribed application fee. 25D Further particulars. The authority may ask an applicant under Section 25C to give it any more information that it reasonably requires to determine the application, and may refuse the application if the applicant does not comply with the request within a reasonable time. 25E Decision on Application for Certificate of Consent. 1. The authority must issue a certificate of consent for domestic building work if it is satisfied that A. The applicant has complied with Sections 25C and 25D, and the applicant has the prescribed knowledge of the duties and responsibilities of an owner-builder, and B. The applicant is the owner of the land on which the domestic building work is to be carried out, or the application is authorized under Section 25F, and C. The application relates to the carrying out of domestic building work in relation to, or ancillary to, a single dwelling, and D. The applicant resides and will continue to reside, or intends to reside, in the dwelling, and E. The applicant has not been issued with a building permit for the carrying out of domestic building work by the applicant as a builder on land owned by the applicant, or a related body in the previous 5 years other than in relation to I. The dwelling on the land to which the application relates, or 2. A Class 10 building that is ancillary to the dwelling on the land to which the application relates, and F. If the applicant co-owns the land to which the application relates with another person, a building permit has not been issued to that person for the carrying out of domestic building work by that person as a builder on land owned by that person in the previous 5 years other than in relation to I. The dwelling on the land to which the application relates, or 2. A Class 10 building that is ancillary to the dwelling on the land to which the application relates, and G. If the applicant was the co-owner of land, other than land to which the application relates, with another person in the previous 5 years, a building permit has not been issued to that person for the carrying out of domestic building work by that person as a builder on that land in that 5-year period, and H. The applicant I. is not in the business of building, or 2. has been exempted from the requirement to be registered under Part 11, or 3. is a registered building practitioner whose registration does not authorize the carrying out of the work to which the application relates. 2. The authority must refuse to issue a certificate of consent to an applicant if the authority is satisfied that the applicant has at any time entered into a contract to sell a building constructed by the applicant without obtaining the required insurance in contravention of Section 137B2b. 3. Subject to subsection 4. The authority must refuse to issue a certificate of consent if the requirements of subsection 1 are not met. 4. The authority may exempt an applicant from the requirement in subsection 1E, 1F, or 1G if the authority determines that special circumstances exist. 5. For the purposes of subsection 4, the authority may determine that special circumstances exist if it is satisfied that A. The application arises from a substantial change in the circumstances of the applicant, or B. The applicant would suffer hardship if the application were refused. 6. In this section, Class 10 building has the same meaning as it has in the Building Code of Australia. Related body means a body corporate of which the applicant is a director, or the trustees of a trust of which the applicant is a beneficiary. 25F applications in relation to land owned by related bodies. 1. An applicant for a certificate of consent in respect of domestic building work is not required to be the owner of the land on which the work is to be carried out if A. The land is owned by a body corporate, and B. The applicant is a director of the body corporate, and C. The body corporate has in writing authorized the applicant to make the application and to carry out the work. 2. An applicant for a certificate of consent in respect of domestic building work is not required to be the owner of the land on which the work is to be carried out if A. The land is the subject of a trust, and B. The applicant is a beneficiary of the trust, and C. The trustees of the trust have each in writing authorized the applicant to make the application and to carry out the work. 25G Certificate of Consent. 1. A certificate of consent issued under this division. A. Must contain the prescribed information, and B. Expires I. At the end of the prescribed period, if a building permit is not issued in respect of the building work to which the certificate relates within that period, or 2. On the date that the building permit lapses, if a building permit is issued in respect of the building work to which the certificate relates within the prescribed period, or 3. On the day on which the owner of the land to which the certificate relates ceases to own the land. 2. In this section, prescribed period means A. The prescribed period by the regulations, if any, or B. If a period is not prescribed, 12 months. 25H Register of Certificates. 1. The Registrar of the Victorian Building Authority must keep a register of certificates of consent issued under this division. 2. The register must be kept in accordance with the regulations. 3. The authority may publish prescribed information kept on the Register of Certificates of Consent on the authority's website. Asterisk 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 asterisk. 25J Review by VCAT. A person to whom a decision of the authority under this division applies may apply to VCAT for a review of A. That decision, or B. A failure of the authority to make that decision within a reasonable time. Division 4 Special Provisions. 26 Prescribed Places of Public Entertainment. An application for a building permit for a place of public entertainment prescribed, or in a class prescribed for the purposes of this section, must be made to the authority. Asterisk 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 asterisk. 28 Historic Buildings and Special Buildings. 1. Despite Section 24, the relevant building surveyor may issue a building permit for the carrying out of building work that does not comply with the building regulations if the work is to be carried out on, or in connection with A building included on the Heritage Register established under the Heritage Act 2017. Asterisk 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 asterisk. 2. The building permit may be issued to enable the carrying out of work appropriate to the style, manner of construction, and materials of the building. 3. In deciding an application for a building permit in respect of a building to which subsection 1 applies, the relevant building surveyor must take into account A. The structural adequacy of the building, and B. The requirements necessary to make reasonable provision for the amenity of the building, and the safety and health of people using the building. 4. The consent and report of the Executive Director under the Heritage Act 2017 must be obtained to an application to demolish or alter a building which is on a register established under that Act. 29 Subdivision. 1. Despite anything to the contrary in this Act or in any other Act or law, the relevant building surveyor may refuse to issue a building permit for the construction of a building if A. The owner from time to time of the land could dispose of part of that land without proceeding under the Subdivision Act 1988, and B. The relevant building surveyor is satisfied that if part of the land were disposed of before the council considered the matter, the building to be constructed would not comply with the provisions of the relevant planning scheme or of any regulation made under this Act, or of any local law made under powers conferred by the regulations made under this Act with respect to I. The dimensions or area of the land, or 2. The proportion of the area of land on which buildings are to be constructed, or 3. The provision of open space on the land. 2. The relevant building surveyor must not, under subsection 1, refuse a building permit for the construction of a building on the sole ground that the owner may without notice to the council dispose of part of the land to the Crown, or to a public statutory body constituted under a law of the state, or of the Commonwealth. 29A. Application for building permit for demolition. 1. If an application is made to the relevant building surveyor under this Act for a building permit for the demolition of a building on land N. A. The demolition and all other demolitions completed, or permitted in respect of the building, within the period of 3 years immediately preceding the date of the application would together amount to the demolition of more than 1/2 of the volume of the building, as it existed at the date of the first building permit to be issued within that period for the demolition of any part of the building, or B. The demolition is of any part of the facade of a building. Then the report and consent of the responsible authority under the Planning and Environment Act 1987 for the planning scheme relating to that land must be obtained to that application. 2. The responsible authority as reporting authority must refuse its consent to an application to which subsection 1 applies if a planning permit is required for the demolition and has not been obtained but must not otherwise refuse its consent to the application. 3. In this section, facade means A. An external wall, including any veranda, balcony, or balustrade, or architectural feature attached to or forming part of an external wall, or B. A part of a roof, or C. A chimney that faces a street, and at least part of which is visible from the street it faces. Street includes road, highway, carriageway, square and court. 29B. Suspension of demolition permit pending amendment of planning scheme. 1. If A. The report and consent of the responsible authority as reporting authority under Section 29A has been sought in relation to an application for a building permit, and B. During the prescribed time referred to in Clause 6A2 of Schedule 2. I. An application is made to the Minister for an exemption under Section 21 of the Planning and Environment Act 1987 in respect of an amendment to the planning scheme affecting the land, or 2. If a request is made to the Minister to prepare an amendment to a planning scheme affecting the land, and to exempt himself or herself under Section 24 of the Planning and Environment Act 1987 from certain requirements in respect of that amendment. The responsible authority must give written notice, without delay, to the relevant building surveyor of the application or request. And consideration of the application for the building permit. 3. The responsible authority must give written notice to the relevant building surveyor without delay of A. The withdrawal of an application or request referred to in subsection 1b, or B. The refusal of an application or request referred to in subsection 1b, or C. The coming into operation of an amendment referred to in subsection 1b, or D. The lapsing of an amendment referred to in subsection 1b. 4. The prescribed time within which the relevant building surveyor must decide an application for a permit A. ceases to run at the time that notice affecting the application is received by the relevant building surveyor under subsection 1, and B. recommences to run only when notice affecting the application is received by the relevant building surveyor under subsection 3. 5. If a notice of an amendment has been given to the relevant building surveyor under subsection 3c, the relevant building surveyor must, in considering under Section 24 whether a building permit is consistent with any relevant planning permit, consider the requirements of the relevant planning scheme as amended by the amendment. Division 5, Register and Records. 30. Relevant building surveyor to give copies of permits and documents to council. 1. The relevant building surveyor, within 7 days after issuing any building permit under this part, must give to the relevant council a copy of that permit and any plans and other documents lodged with the application for the permit. Penalty: 50 penalty units in the case of a natural person. 250 penalty units in the case of a body corporate. 1A. In addition to the requirements of subsection 1, the relevant building surveyor, within the relevant prescribed time, must give to the relevant council a copy of any other prescribed documents relating to the application for the building permit or the permit. Penalty: 50 penalty units in the case of a natural person. 250 penalty units in the case of a body corporate. 2. Any documents lodged with the relevant council under subsection 1 or 1A must be accompanied by the appropriate prescribed lodgment fee, if any, paid to the relevant building surveyor under Clause 1 of Schedule 2. 30A. Authority may approve checklist of documents to be certified. 1. The authority may approve a checklist of all documents required under Section 30 to be given to the relevant council by the relevant building surveyor. 2. The authority must publish the approved checklist on the authority's website. 30B. Relevant building surveyor must certify that documents given to council. The relevant building surveyor must A. Certify on the approved checklist that I. All documents required under Section 30 to be given to the relevant council have been given to that council, and 2. Any lodgment fee required under Section 32 has been paid. B. Give the certified checklist to the relevant council at the same time as the documents required under Section 30. Penalty: 10 penalty units. 31. Register of building permits. 1. A council must keep a register of all building permits given to it under this division. 2. A council must make the register available for inspection by any person during normal office hours. 32. Keeping of records. A council must keep all documents given to it under this division for the prescribed period and in the prescribed manner. 32. A council to notify Development Victoria of issue of building permit. 1. This section applies if A. A council has under Section 30, 1. Been given a copy of a building permit issued for building work to be carried out on a property situated in a project area within the meaning of the Development Victoria Act 2003, and B. A resolution is in force under Division 5A of Part 3 of that Act levying a general development charge or infrastructure recovery charge in respect of that project area. 2. The council must within 14 days after being given the copy of the building permit A. Notify Development Victoria in writing in accordance with subsection 3 and B. Provide Development Victoria with a copy of any relevant planning permit that it holds that authorizes both the construction of the buildings to which the building work relates and a subdivision of the land on which the building work is to be carried out.